We'll get started. Our first speaker this afternoon is Joe Lux. And Joe and I went to law school together. He was kind enough to present on this topic when I called. And it will be about what the Supreme Court has looked at. And as far as business litigation goes, he'll be giving us an update or a survey on business litigation law. Joe did graduate from the University of South Dakota School of Law, was on law review there, and is with the Costello Porter law firm here. Thank you, Joe.
Everyone who's here gets extra credit. I really didn't think this through very well. I should have revised the scheduling. Whoever thinks that an update on cases is a thing to have right after lunch has never presented this particular session before. Anyway, I'm from Costello Porter, and I've been there for 20 years next month. And I'll be presenting today on recent developments on business law litigation. Now, it was pointed out to me when I ran this through some folks at the office that I'm looking pretty darn good for being Joe Lux since 1889. And I acknowledge for 124, I'm not really all that bad. Actually, the firm is going to be 125 next year. I'm a long way from there. So we've got a number of things we're going to talk about today. And the pleasure that I get is deciding, all right, if we're going to do an overview, what are we going to overview? There's a ton of cases out there. So first off, we're going to set a time frame. July 1 of last year through the end of September of this year. And we're going to take a look at some cases that had some interest for me, and I think some will have interest for you. We'll take a look at cases from the South Dakota Supreme Court. We'll take a look at the 8th Circuit Court of Appeals, and believe it or not, a few cases from the U.S. Supreme Court. Now, many of us also practice in the district courts for the state of South Dakota. But I chose to ignore most of those, all of those, for two reasons. One, there's a boatload of them, and two, any of them would be subject to appeal or something. So I only took the ones that had been resolved on appeal, either through the 8th Circuit or the U.S. Supreme Court. So for other details or interesting cases, I'm sure of the 347 cases that I found when I did a search to group them all together, there's bound to be some nuggets in there, but that's part of your own search, and I decided not for me. Now, when you look at business cases, there's an interesting group of things. They cover the gamut, just like private party cases would run through. But business cases have this annoying habit of being complex. There's procedural challenges, and we'll cover some of those cases today to see what some of those challenges might be. There's always issues. In your printed materials that you've got there, I've highlighted some issues for those cases. On the whole, I did not highlight all of the issues. Some of them are just a rehash of issues that are fairly commonplace, and so what was the point? Besides, they wouldn't fit on one slide, so I wasn't going to do that. But another thing you'll note in looking through these cases as they go on, and on, and on, and they go to appeal, and then they go back for trial, and they go back for appeal, and they go back for trial, and then they go back for appeal, and then they go back for trial. And guess what? There's another appeal on its way. So some of these are like retirement cases for the attorneys involved. Some of these might even last generations, who knows? But they are a rather interesting group of cases. They're usually about large sums of money. For businesses, it's bad business to have to go to court. So at least in my practice, frequently there's an effort made to try and find some way of resolving matters. Some way of getting through the problem, because Rapid City, like Sioux Falls or anywhere else in the state, it's really a fairly small community. As between businesses, there's a limited number of people you can do business with. A lawsuit tends to burn bridges as opposed to merely cripple or injure those bridges. But even so, there are times where the lawsuit is going to take place. Like I say, they're usually about large sums of money, except when they aren't. It's an amazing thing how people will dig their heels in. My favorite case, we'll talk about it later, concerns the car. It's a 2004 Honda Civic that became the subject of litigation that went all the way to the Supreme Court. At that point, the car was an 8-9-year-old car. How How valuable a car is this really? The court opinion doesn't describe it, so I had to go back to prior opinions to find it. I'm thinking Lamborghini, some one-of-a-kind model, first run edition. No, 2004 Honda Civic. So I just like that one, so you're going to have to suffer through that one with me here after a bit. Class actions. There is one of them that the South Dakota Supreme Court looked at, and in some ways, the class action suits fall down the difference between state court perception of them and the U.S. Supreme Court. Now, for those of you who get, like I do, these zillions of emails updating for seminars such as this, there's a lot of seminar possibilities going on right now about what the Supreme Court has done concerning class actions and arbitration. We're going to look at 3 of them today, both here and in your materials. One of them takes an application of facts to the established law. Another one takes a look from the viewpoint of it's a matter of contract. And then another one is going to take a look at it from the arbitrator's authority. What can he do in respect of class action designations? It's really rather an interesting group of cases there. Many of the cases we've got, no surprise, come down to contract interpretation. I've included a number of insurance cases for today. There's an infinite number of insurance cases. Many of them revolve around it, have a similar fact pattern, have similar outcomes. It's just that people apply different weights to them, so they therefore go to court. In my presentation remarks, I'm unlikely to cover insurance ones, though they are obviously business litigation ones. Zoning. We'll get to a zoning one later. But zoning is really another form of contract. It's a contract between the municipality in this case and individuals who do business in the municipality. In this case, it would be Lamar Signs in Rapid City. There was a dispute. I'm sure it doesn't occur elsewhere, but Rapid City doesn't like billboards, and that was basically the zoning one. And on appeal, it was decided, no, you can't change the rules in the middle of the game. They mean what they say. You apply them 100 times. You can't change because you've decided you've got a particular distaste. So it's basically zoning as a contract. The stock purchase agreement will come into play. And now I quoted the agreement because clearly if there was an agreement, they wouldn't be in front of the court. So there's a dispute. Is there or isn't there? That kind of a case is going to be relevant not only in the business world, but it's between individuals as well. Parole evidence had a big show this past 18 months or so. I didn't include any of the U.S. Supreme Court cases on it, but South Dakota and other courts have had a lot on the parole evidence rule. It's more than they usually would. We'll look at some damages. There's a warranty damages case that's rather interesting, mind-bogglingly complex, so I think I'll save that for your leisure reading it in the materials rather than from up here. There's a number of interesting cases concerning awards of attorney fees and, of course, the perennial favorite of punitive damages. Now you have it, now you don't. Seems to be a common theme. South Dakota's hard to get punitive damages, but it's not impossible. A lot of rules cases, civil procedural rules, evidentiary rules have excluded any of the criminal rules, and there are a couple of cases on that in the business context. We're going to apply some new facts to old rules. We're going to look at interpretation of amendments to rules. You'll recall that most of our procedural rules are rules of procedure established by our Supreme Court, and the court has done a few of those. And then there's a case where you're stung by a new rule. And I like this one just because it has to do with bees, and there's a lot of great pictures of bees on the internet. So we're going to start out with talking about this case here. Ellingson. Now it's titled Ellingson versus Amen, but I think it's more accurate to describe it Ellingson versus Ellingson. What the case is Mr. Ellingson had a business, beekeeping business. He decided to get out of the beekeeping business, and but he thought he would try and nail down he personally, but his company would try and nail down places and fields where he could position his bees so that they could continue to generate income. But there was a competing beekeeper, and the question was, who was he competing against? Well, Mr. Ellingson didn't keep bees, but his company did keep bees. Now you can probably see what's going to happen here. Mr. Ellingson filed suit for interfering with the business relationship. And he sued this other competing company run by Mr. Amon. And he says, because he came in and undercut, the bids. So he paid the farmers and ranchers more money to put his bees on the property, so they did not follow through with the contracts that they had for Mr. Ellingson. Or they blocked the farmers from actually executing documents so that they could lease the space. Well, Mr. Ellingson was a little bit stung by this behavior, so he decided he's going to go to court. And go to court he did. And he sued in his own name. And it became apparent that, well, Mr. Ellingson didn't own any bees. He had never owned any bees. He had no intention of owning bees. But his company did. But his company never filed the lawsuit. His company never did anything. So, unfortunately for Mr. Ellingson, he got kicked out of court. It was a bad deal for him, but it just goes to show sometimes you need to hire a lawyer. In several of these cases had bad outcomes because they save money by not hiring a lawyer, and they had rather an unpleasant outcome as a result. So he was an aggrieved party in the case of Smith versus Rustic Home Builders. Well, we thought he had an aggrieved party. This is found in page 9 of the materials from my section here, and it's another procedural case. Well, Jay Dreesen was a named defendant along with Rustic Home Builders, and Jay was a manager for the company. The company, unfortunately, just sort of ignored the whole thing, and the day came where a default judgment was entered against the limited liability company. Rustic Homes had the default. The claims against Jay, on the other hand, were dismissed. Time passes, and the Smiths and Rustic Home Builders and Jay, they continue oddly in various negotiations and attempts to satisfy the claims against the company. And eventually, his efforts to get the default judgment released 5 years later failed. So, Jay appealed, and he appealed on behalf of himself and the LLC. You can probably guess what's going to happen here. Some years ago, the case of Sunflower Railroad. Amongst other things, Sunflower established the principle, which it had established in the case just slightly earlier, that a corporation isn't a person. It isn't a natural person. Natural persons can represent themselves. Unnatural persons, such as a corporation, cannot represent themselves. Not really earth-shattering, but it was probably earth-shattering for the principals of Sunflower Railway Company to discover that, in fact, whether they were managers and principals in the company or not didn't matter. They could not represent themselves. So, what are we going to do? Well, are we surprised an LLC isn't a natural person? Same rule is going to apply. If you're going to be an LLC, you have to have an attorney represent you. Jay was a manager. He clearly was involved, but he couldn't be an aggrieved party because the claims against him at the time of the appeal had been dismissed like 6 or 7 years before. So what did he have to complain about? Well, the court said nothing. But he felt himself an aggrieved party, but there were no aggrieved parties or any other party, I presume, after that case was over with. Now, the rule against corporations or LLCs not being able to represent themselves has an exception for corporations if they find themselves in small claims court or they go to small claims court. They can have representation by a manager or shareholder or somebody in charge of the company. And the court established a rule to take effect the 1st of January where LLCs can do the same thing in small claims court, which leaves an open question that I don't really have an answer to, and that is, a lot of small claims actions get moved to the formal side of court. Can they continue to represent themselves once you've moved to the formal side? I would suggest I would probably argue that no, they could not. Some of our clients would probably be disagreeing with us on that point, but I think once you leave small claims, and I haven't actually seen the rule that was published in the Bar Newsletter last month or the month before, and I just sort of skimmed over it until others in the office reminded me of it there, but I don't know that the question has been answered, what happens if you leave regular small claims. But I'm quite sure someone here or somewhere else in the state is going to find the answer to that, and on something not nearly as valuable as in 2004 Honda Civic, they'll find themselves arguing about it. Which, I'm going to digress for just a moment. One of the cases that I've got, I believe it's Mark's, it's all I give them the second or third pages, is another small dollar amount claim. That one went to the U.S. Supreme Court as well. It was a Fair Debt Collection Practices Act case. An individual felt that the creditor was calling too much and harassing him, so brought suit. The harassing creditor made an offer of judgment of $1,500 plus reasonable attorney fees and costs. So we're fighting over $1,500 plus reasonable fees and costs, and the plaintiff never responded to it. Well, the case proceeds to court, goes to trial, and the plaintiff loses. The plaintiff should have accepted the $1,500, but no, we're going to stand on principle here. And for $1,500 that they could have received, they brought an appeal. And attorney fees were awarded against the plaintiff for bringing the action against the creditor. $1,500. And the dispute was which law applies concerning the award of attorney fees. Well, Federal Rule of Procedure 54 talks about when you can award attorney fees. And there's no mention of bad faith. In the Fair Debt Collection Practices Act, there are provisions for attorney fees if there's evidence of bad faith. And the question was, did one rule trump the other? And it was decided that no, the Federal Rule of Procedure was not trumped by a specific rule that permitted bad faith award of attorney fees. The regular rule was not confined to bad faith in that control. But $1,500, and it made it all the way to the U.S. Supreme Court. That was one ticked off private individual, because I can't imagine what that actually cost to proceed. But common sense. I know it doesn't happen to you guys, but some of my clients don't exercise the best of common sense. And sometimes I really kind of fail at this client control bit that they teach you in law school. And sometimes they will do what they will do. And I suppose that's what occurred on that $1,500. In 2006, our state Supreme Court amended 15652A, which concerns findings of fact and conclusions of law. In those amendments, the court deleted the earlier requirements that you had to have formal findings and conclusions, circulated, commented on, and then issued by the court. In this particular case, they did not. And it'd be great if I could remember which case I'm about to be talking about here, because I seem to have lost it. The People versus Lester case on page 8 is what I'm talking about.
It's unclear from the opinion
As to whether or not the parties raised the question about the lack of formal findings or not, but the court took it upon itself to ensue on a rather detailed and unnecessary, in my view, since I don't see any justices sitting here, a discussion of that point. But the rule is very explicit. It says a memorandum decision that recites the findings and conclusions satisfies the requirement of findings and conclusions, which of course you need so that there can be a sufficient review on appeal. The Farnsworth on contracts and the restatement second of contracts, those make reference to the use of parole evidence in cases where you're claiming fraud in the inducement. We've got several of those cases here that we'll be visiting about, either with me standing up here and enlightening us all, or else in my materials, which will probably be slightly more, and certainly quicker. The prior case concerned fraud in the inducement, and Stern Oil Company is another case that was talking about fraud in the inducement. Well, some 12 years prior to the Stern case, which is the 2012 one, the Schweiger versus Mitchell Radiology Associates concerned a physician who had been hired, and he felt he was going to be employed to become a full and equal partner, and a number of other disputes were raised. The contract that he was presented with varied from that, and it didn't define what a full and equal partner was. It was the belief of Dr. Schweiger that he had been fraudulently induced to enter into his employment agreement. That was argued through the courts, and there were other related cases to the Schweiger versus Mitchell Radiology. But it was determined by the court that no parole evidence rule does bar in the Schweiger case. If you've got, it's patently unreasonable for a person to say they relied on an oral statement when the contract itself varies from it. So the Schweiger case says, no, we can't use parole evidence. You cannot establish fraud in the inducement through the use of parole evidence. Well, it really begs the question, how do you ever prove fraud in the inducement? Because by its nature, it's not going to be in the contract. These cases here, the Stern Oil Company and the Pebble case, revisited the question about whether Schweiger was in fact really good law, and in Stern Oil Company, Schweiger was abrogated. Now, I don't know if that's just the new word we use. We don't overrule anymore. We just abrogate it, but it's been abrogated, and if there is a fraud in the inducement claim, parole evidence will be permitted. And so the two cases that we've got here, the cases were reversed because the trial court, of course, followed Schweiger, which said, no, you can't have parole evidence. Now, the court did try to distinguish in the Stern Oil Company the facts of Schweiger. In Schweiger, there was an allegation of fraud in the inducement. And for those of you who are familiar with the rules, if you're going to plead fraud, you have to do so with specificity. The specificity was probably the bigger problem in the Schweiger case, but the statement that resulted from it was very, very broad, just said, period, in the story, you can't have parole evidence. Stern Oil and the Pebble case actually examined that a little bit closer, and in those cases, there were allegations, specific allegations, of what the nature of the fraud was that they felt had been perpetrated on them. And it was determined that, yes, indeed, if there is specifically pled fraud, the case can go forward. Now, there was a big argument both in the trial court and at the Supreme Court level about summary judgment and what does that actually mean in the realm of fraud. This was a 3-2 decision, so there's some unrest yet within the court on this particular case. Fraud in the inducement in this case is, of course, in the context of an oil contract, but it would apply for purchases of homeowners or anything else, a car. But the argument was, what kind of proof is necessary? Fraud has a number of elements. In the Stern Oil case, some of those elements were pled with what the majority of the court said was sufficient specificity. And they made clear that you don't have to prove at the summary judgment stage, you don't have to provide evidence on every one of the elements of fraud. You just have to have something there that would preclude the grant of summary judgment against you. And there was a big argument about what kind of evidence is necessary. The dissent, you could seem to read the dissent by saying that they support a theory that on summary judgment, you have to bring forth sufficient evidence on which you could make a finding. The majority said, no, you don't. You just have to have sufficient evidence which, if believed by the fact finder, could lead to a judgment. But you don't have to prove the point here. You don't have to find beyond any burden of proof at the summary judgment stage. Just that there's evidence that somebody, reasonable fact finder, could believe. But there's a lot of disagreement on the Stern Oil case as to what do you do at the summary judgment stage for parole evidence? How much evidence? My takeaway is, and this probably applies in every fraud case, is you need to plead as much as you can, as much as you're able to find at the time you file the complaint. That's correct.
From a drafting standpoint, is there anything we need to take away from these two parole evidence cases that we can put in our documents, that we have the standard, there's no oral representations? If I have a client that comes in, I want to make sure, I don't know what he's told prior, but I want to try to protect it in my document. Is there anything that I can put in my document that will withstand, be helpful in these cases that says the whole evidence really doesn't apply to us?
Well, the question is there some way around this to block parole evidence from being admitted? The two cases we have here did not have a clause in their contracts, apparently, that specifically recited that all prior negotiations are subsumed into this. There was nothing that foreclosed bringing in any other evidence. And in the Pepple case, there was a comment to that effect, that there was nothing in their document that said this was the final statement and it trumped all of the prior oral representations. My takeaway